I'm going to pass it back to Lewis now with that sort of information and let him take us through a bit of the background of the ADA and how we got here. Back to you, Lewis.
Thanks, Jason. Again, as I mentioned briefly in the introduction, the ADA is a civil rights law. It was enacted to protect against discrimination based on disability. It was enacted in 1990, so kind of put yourself back to 1990 era. The internet was not a thing. Email really wasn't as nearly as ubiquitous as it is now. The ADA was really designed to deal with physical barriers. The technological issues were a footnote to the statute. The ADA imposes accessibility requirements on public accommodation. Is your facility a public accommodation? So if you think about, in the traditional sense, banks, sports arenas, restaurants, public accommodations. When we think about that in digital form, it takes on a different perspective. Think of web access that is not password protected or restricted. Are you selling goods, services on the internet? And the idea that the internet is now a place of public accommodation is a relatively new concept. But again, as the last point notes, again, in this analog law, it was designed to address physical accessibility issues with traditional brick and mortar storefronts.
Lewis, this is Jason. I wanted to just build on that to get people to understand how complex this is in the digital space compared to analog. And you may have some points to add, but in the physical space, access was all about getting into a building, not how that business operated. In the digital space, digital is everything about how do you do banking, how is the banking service delivered to you, how is the shopping experience delivered to you. That's all digital. So it becomes it's a far more complex question.
On the screen is the language of Title III of the ADA. You all can read that. But that's really, that's the text of the language that was originally enacted, which talks about places of public accommodation. And again, what does Title III cover? Places of public accommodation. You can read what it covers. The relief available under Title III is injunctive relief. You can get attorney's fees and costs, but there's no compensatory damages and civil penalties. What we're seeing in the thousands of lawsuits that have been filed over the last 2 or so years against virtually every industry sector is a combination of a claim for a violation of the ADA seeking injunctive relief paired with what we call the mini ADA statutes, the state civil rights or human rights laws. The most common one is the New York State and New York City human rights laws. And the reason that those are added into the complaints is because those are the statutes that give rise to the monetary damages. The ADA itself does not provide compensatory or civil penalties. It's injunctive relief only. The money damages come from application of the mini ADA or the state ADA-like statutes. This, the problem that we have, and I alluded to it earlier, is while we know to the inch how wide a curb cut has to be, that's because there are regulations that have been enacted that tell us those things. The question that we have to ask is, where the heck are the regulators here? DOJ is responsible for providing guidance as to what is required under the ADA. They are responsible for enforcing the ADA. In 2010, the DOJ issued a notice of advance proposed rulemaking, which would have adopted technical rules for website ADA compliance. You would think that that would be a relatively uncontroversial, easy thing to enact, yet it got kicked around from working group to study group, back to working group, out for comments, back and forth. And the next thing you know, it's 2016. We'll talk about in a moment WCAG, the Web Content Access Guide, which is now at version 2.1, which was poised to be enacted, did not get enacted. The current administration came in on a platform of deregulation, And generally speaking, any regulation that had not been formally adopted got pulled. WCAG, the technical specs for web access, for what would make a website ADA compliant, got pulled. So the law, like nature, abhors a vacuum, but we have a vacuum. And what filled the vacuum were these thousands of lawsuits that basically say to the commercial community, there is no ADA compliant website out there. WCAG, again, the Web Content Access Guide, was originally promulgated by the Worldwide Consortium. The Worldwide Consortium are the people who brought us the www configuration that is now as commonplace as the nose on your face. They came up with this Web Content Access Guidelines that would have provided the and do provide technical guidelines that assure web compliance with the ADA. They are considered by many groups to be the true means of ensuring website accessibility, except they've not been formally adopted. What you're seeing now is, on a piecemeal basis, courts applying the WCAG standard because no other standard really exists. Legal standard that can be applied now is the 2010 standard, which is, does your website provide, quote, effective communication, end quote. For the lawyers on the line, and others may be familiar with these concepts as well, the fact that there is no legal standard that you can measure your compliance against means that if you want to defend a lawsuit, you're going to have a really hard time getting the case dismissed at the earliest possible dispositive motion point, which is Rule 12 motion to dismiss. Because the question as to whether your website provides effective communication is now a question of fact. And questions of fact can first be resolved at the Rule 56 stage. It could be that the parties agree there are no materials issues of fact in dispute, and that one party or the other should win as a matter of law. That's the Rule 56 standard. But if you know, between Rule 12 and Rule 56 sit the discovery rules, the 30s. That's where the cost of litigation comes up. That's where the void, the vacuum, that not having regulations promulgated and enforceable come in. That's where the plaintiff's counsel's lawsuits come in, because they're filing these lawsuits knowing that it's going to be really difficult to get a motion to dismiss granted. So they're looking to settle these lawsuits on an individual basis at that early point. So they're saying, basically, we'll settle with you for just about and perhaps a little less of what it would cost for you to file a motion to dismiss, but settling with us brings certainty to a certain extent because you're only settling on an individual basis, not a class basis. But the fact that WCAG 2.0 was never formally adopted is what creates that vacuum and is the difference between knowing to the inch how wide the curb cut needs to be and not. Jason, do you want to talk about what's happened here?
This hopefully shows the data that Lewis talked about. And I think it's important to go back to the year 2000 in the case of web accessibility and app accessibility. The DOJ have joined over 15 years from the year 2000, many cases where they felt that it was very important that organizations were providing digital access to all. Some of the first settlements were with people such as Bank of America. So think of very important aspects of your life and everyone's life, which is banking, education, healthcare. These are the types of lawsuits that the DOJ joined the plaintiffs. And in these cases, most of the plaintiffs were what I class as traditional advocacy groups like the National Federation for the Blind and weren't individual plaintiffs. But essentially, the DOJ did spend 15, 16 years establishing that they truly believe that the ADA covers web and apps. They probably would argue they tried to do a good job of establishing that the WCAG 2.0 was a standard that they felt acceptable in settlements. So essentially, defining what the standards were. But this moment in 2017, which essentially meant that those, as Lewis said, those technical standards were not added to the statute, meant that the legal position was open and available for people to take that standard the DOJ created of saying, well, every website and app should be accessible, and actually the WCAG 2.0 is something that I could use to determine whether a website is or is not accessible. And that gave plaintiffs and plaintiffs' law firms the opportunity to basically go in and create a volume amount of lawsuits against companies. And you can see since 2017, we're talking about thousands of federal lawsuits. Lewis is going to talk about it's not just about federal lawsuits. He's going to talk about state lawsuits. It's also demand letters. But I also think there was something that Lewis explained to me, which I think is very important, that's missing today. It's not just the missing WCAG 2.0. It's also the missing of, well, how long does a company have to do this? What is the process that someone could report that they're having issues? So there's such a gap in the legislation that these lawsuits have sort of the room to breathe. However, I'd say two things. The DOJ weren't quietly doing this. Most companies should be aware that they should have accessible websites, but I think most companies have done less than they should have, so they've exposed themselves. And at the same time as the DOJ was doing this, federal and state laws were being established, such as the Section 508 and educational-based, requiring websites to be accessible. So this isn't a surprise technology. It's not a surprise that you should make sure your websites are accessible or your apps are accessible. But I don't think most companies have taken it and made it a priority that they probably should do today.
Stay on this page for a moment. There's two things I want to mention about this. One is, in the case that we brought against the government to make its website ADA compliant, the sticking point was the government itself would not agree to make its website WCAG 2.0 compliant. They took a very hard line that the legal standard was effective communication, despite the fact that in the consent decrees that they were entering into in those 222, the 46, the 4 cases on the top line, they were imposing WCAG 2.0 on the defendants in that case. They just refused themselves to be subject to that same standard. The other thing that you'll note, and it bears out what we said earlier, is when they pulled the WCAG standard from the Notice of Advanced Proposed Rulemaking, that's where you start seeing the spike in cases. DOJ has basically ceded enforcement of the ADA to the plaintiff's bar. And you're seeing that those 3,000 cases filed between 2017 2018, and the trend has continued unabated in 2019. If you could go ahead and open the poll, and it asked the question of how confident do you feel you understand what's required by your, of your website, or in order to make your website ADA compliant.
The poll's back, basically a typical poll result, I think, as well for us, which is around 50% of people got a good idea, 50% of people don't have a strong idea of whether their site is ADA compliant. If you could take us from here, Lewis, through the legal trends that you're seeing today, that would be very useful.
Yeah, thank you. Reflecting on those poll results, there's nothing surprising about those poll results. We have defended several hundreds of these cases. And I would say in the majority of them, and when I say majority, I'm talking over 75% of the cases, the IT departments tend to already know about the problems. In fact, they knew about them several years ago. But because of resource allocation, the fact that no one was really complaining, these issues got pushed to the back burner. But now that these lawsuits have been filed, what I hear a lot from IT departments is a sense of vindication. Hey, we've been telling them that we've got this problem. Now we're actually going to fix it. So the idea that people say, yeah, I'm fairly confident that I know the problem, is not an unexpected response. The next question, though, is, but have you remedied those problems? And are you still exposed to litigation risk because of extant problems? And with that, let's talk about some of these litigation trends. The private lawsuits allege generally that the websites are not compatible with the ADA, that they don't provide access to blind and visually impaired individuals, and that they don't meet WCAG 2.0, although they've gotten a little savvier, and the lawsuits more recently aren't citing to WCAG 2.0 because it is not the enforceable standard. The standard, as we've discussed, is does your website provide effective communication? The lawsuits seek remediation of the website, and most, but not all, also assert violations under the mini ADA or state ADA actions. So the questions that you need to ask are, is your website a place of public accommodation? So if you are a bank and accessing your bank's website brings you to a dialog page that requires you to enter a username and a password, I would argue that your website is not a place of public accommodation. If your website, however, is one of the millions of websites that I got ads for over the last several days saying, Cyber Monday, come visit my site and everything is 20% off, I'm fairly certain that someone's going to conclude that your website is a place of public accommodation. And there are various gradations of that. So are you providing information on your website, but really no access for sales? Again, generally speaking, informational-only websites are not places of public accommodation to the extent they are not offering for sale goods or services. But could the information lead to the purchase of a good or a service? There are some courts that have taken a very narrow, or depending on your perspective, very expansive view of what constitutes a place of public accommodation, and they have said that if information is reasonably likely or linked to the purchase of a good or service, then the information will be considered a place of public accommodation. So first, is your website a place of public accommodation? I think we have to view that expansively and assume, unless we can determine that it is not, the presumption is that most websites are places of public accommodation. Again, painting with a broad brush there, but as a general proposition, most websites are places of public accommodation. Then the question is your website compliant? And the question there is compliant by application of what legal standard? Does it provide effective communication? Or is it WCAG 2.0 compliant, which is a way of saying it provides effective communication as judged by the objective criteria of WCAG? But again, WCAG is not the formal legal standard, but it is a way of establishing that your website does in fact provide effective communication. And then we get to the question, there are some more kind of ethereal questions. Does the plaintiff even have standing to bring the lawsuit? There was a case recently where a plaintiff sued a credit union, and the credit union successfully defended the case and defeated it at the motion to dismiss Rule 12 stage. How? Not by arguing that the website was not a place of public accommodation, not by arguing that the website did in fact provide effective communication, but by threading the needle and saying this plaintiff didn't have standing because this plaintiff was not a member of the credit union, and more importantly wasn't eligible to become a member of that credit union. So we have to ask those fundamental questions. Unfortunately, that standing issue is not one that is broadly available. You end up asking questions like the Supreme Court posed in its Spokio decision from several years ago: has the plaintiff suffered concrete injury? Courts, as those who are familiar with that standard, when Spokio first came out, the pendulum swung, and courts were saying, wow, you have to do more than plead the naked state statutory violation. The pendulum has swung back, and it's become almost like an Iqbal minimum pleading standard. Have you alleged that there was some harm that befell the plaintiff as a result of going to a website and allegedly not being able to access that website? But the standing issue is one that if you're relying on that wholly, I think it's a thin reed, but it is something that's out there. who should you get involved in the lawsuit? And there's two questions that you have to ask there. One is legally, who should you get involved? And the second question is technically, who should you get involved? Legally, the question that a number of our clients ask and that we ask is, who built their website? Were representations made about ADA compliance in the entity that put together the architecture of the website? Are third parties involved that link through the website, client's website, that are causing these problems? Websites are not wholly contained. They frequently link to other websites. What we're seeing is requests by our clients that they ask third parties who link to their website to certify that their sites are ADA compliant, and a number of our clients are being asked that same question. You link to our website, tell us that you are ADA compliant and how you meet the requirements of the ADA. So there is the legal aspect of who gets involved, and then there's the technical aspect of it, of who best to help you understand the architecture of your website and how best to meet the requirements of the ADA. And that's where UsableNet really has distinguished itself as the leader in the ADA compliance area.
Yeah, I think it's very important to make a note, I think, for everybody here. We talk about thousands of lawsuits. We talk about probably thousands of demand letters. I think it's very important to, and Lewis, I think you touched on this, but the vast majority of these settle very quickly. They settle within 60 days. And it's very interesting how Lewis has helped explain that between the motion to dismiss and the 56. And that's really the expensive part. And essentially, people are realizing that when they get a lawsuit, they ask the technical team, where are we? The technical team probably says, we're not as good shape as we'd like to be. A lawyer hears that. They know that they're going to have a hard time dismissing it based on the fact that the website's not in the place that they want to be. And then they move to settle as quickly as possible to reduce the amount of plaintiffs' lawyers' fees. So that's really the reason why most of these places settle. But I think the most important point at the end is, and Lewis touched about this, and maybe you could talk about practically how you maybe protect yourself more. Most lawsuits are settled with one individual. That does not protect from the next lawsuit if you haven't remedied the issues that you have on your website. What's your experience in that? We're actually seeing about 25% of the lawsuits today are lawsuits against companies that have previously had lawsuits. Is something that you see as well, Liv?
Thank you. That's consistent with what we're seeing. For the first 2 years or so, we weren't seeing a lot of repeat lawsuits. As more plaintiffs' counsel have gotten involved in this, we're starting to see some of the same companies get sued 2 or 3 times. There was an 11th Circuit case that came out this year that said that if an ADA web access case has been settled and the defendant is in the midst of remediating its website, that fact scenario does not provide a bar to another plaintiff suing the company for the alleged ADA violation that occurred prior to the completion of remediation. So how do you protect yourself against another lawsuit? You remediate your website. You make sure that your website is ADA compliant. And let's be clear about this. These are blackmail lawsuits. I don't think I'm offending anyone by saying that. When I ask my clients, how many complaints have you received from blind or visually impaired individuals about web access? The combined number is 0. These are lawsuits that were manufactured by plaintiffs' counsel. I'm not saying that websites should not be ADA compliant. I just think that this is something that has come about as a result of opportunity. Do most websites, in my opinion, provide effective communication? I think they do. I think it's very expensive to prove that, but there's always room for improvement. And there are some websites out there that simply don't provide ADA access. For those websites, and again, and for others, there is room for improvement. The WCAG 2.0, the reason why it was never enacted is there were a lot of questions about safe harbors, about exemptions. So for example, Title I, there is an exemption for businesses of 15 or fewer employees, and there was a lot of debate about the economic burden of requiring WCAG 2.0 compliance on smaller companies.